Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about delay. Cases that should have gone to the Supreme Court of Canada, but didn't. Mr. Poxleitner was charged with some child pornography offenses, and as a result of those charges, he had a trial that was scheduled for 2 days in court. On the first day of the trial, he applied to adjourn the trial on the basis of the fact that the defense strategy had changed, and the trial was now going to take longer than 2 days. The adjournment was allowed. At the next trial date, the main investigating officer testified, indicating that there was another suspect involved in the case. This necessitated a delay as the Crown was now obligated to produce the alternative suspect for the purposes of cross-examination. On the next trial date, the alternative suspect attended, was cross-examined, and in the course of the intervening time between the first date and the next date, the main investigating officer was charged with unrelated criminal offenses. After cross-examination of the alternative suspect, the defense then applied for an adjournment to seek out information relating to the officer's conviction. The information was disclosed at the subsequent trial date, and the defense asked for the officer to attend for the purposes of cross-examination on the additional criminal charges. The officer did not attend, necessitating yet another delay to compel his attendance to answer for the criminal charges and the potential impact that the officer's alleged criminal conduct could have had on Mr. Poxleitner's case. At this time, Mr. Poxleitner brought an application that his charges be thrown out on the basis of unreasonable delay. Essentially, the delays were all caused by Crown not disclosing the existence of an alternative suspect, Crown not disclosing the criminal charges or the circumstances behind them in a reasonable time, the Crown witness not attending for the purposes of cross-examination, and despite all of these delays that were caused by the actions of the Crown and the police in the case, nevertheless, the charges were not thrown out due to unreasonable delay. And this case raises important issues about the pointing fingers exercise that has essentially taken place since Jordan. Since Jordan, all that's been going on in courts, anytime somebody is litigating an issue about unreasonable delay bringing a case to trial, is looking at every single adjournment and going, you asked for the adjournment, yeah, but that adjournment was your fault for this reason. And judges having to sort out this constant finger-pointing exercise to determine who's responsible for delay. The Supreme Court of Canada could have had the opportunity here to clarify that delay is the Crown's responsibility, where it comes from non-disclosure, failure to bring witnesses, or untimely disclosure of important facts that could affect the strategy undertaken by defense in the case. It's not defense delay because defense needs an adjournment to respond to new information that was in the possession of Crown, and yet that's how we're seeing these cases being argued, litigated, and ultimately weave their way up, where people are begging to be heard by the Supreme Court of Canada for some clarification on who's responsible for what in these types of cases. If the Supreme Court of Canada is going to set hard ceilings like they did in Jordan and Cody of 18 and 30 months, then they need to give the public guidance. They need to give the courts guidance as to how to determine who is responsible for what delay. And instead, they have left everything in a mess that has taken more time to resolve than simply outlining this, accepting some of these cases, and determining who is responsible for certain types of delay in certain circumstances that happen more frequently than I think we all like to admit. This was an unfortunate opportunity missed for the Supreme Court of Canada to really solve the problem of delay that's been created since Jordan, where delay applications ultimately lead to further delays of proceedings. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.